Welcome to another episode of Image Rights by N. Mashinini, the only podcast dedicated to image rights in Africa and around the globe. As you know, in this season, we're doing an overview of image rights in Africa, and the focus for today is Nigerian law. I have a special expert guest with me today, who is Awoyemi Ayomide, a graduate of law from Obafemi Awolowo University, Nigeria. He has a keen interest in intellectual property law and corporate finance. He is a chartered accountant in training. He has also published a number of articles on various issues on intellectual property law. He currently leads a team at the African Intellectual Property Network, an organization that is committed to creating awareness on the importance of protecting intellectual property rights in Africa. Hi, Ayomide, how are you? You're muted.
Hi, good evening.
Thank you for joining us on this podcast today. I'm really I'm honored that you've allowed me the pleasure of your company.
Thank you very much for having me. I'm so glad to be here with you.
So Nigeria is an interesting one for me, and I really wanted to get down to find out what is in general, what is the personality rights space looking like? But specifically, what I want to find out from you, as someone who's working in intellectual property rights and, of course, related rights, I wanted to know, how does Nigerian law recognize and protect image rights, if it does at all?
All right. Thank you very much for your question. So, to the extent that everyone has a right to their privacy, a right to their personal life, a right to personal information, to their reputation. The Nigerian Constitution actually recognizes the right of every person in the country to privacy, right? And also, Nigeria has a data protection regulation that also recognizes the right of everyone to their privacy and to the protection of their privacy. However, when we speak of image rights as to the rights associated with the personality of a person, the image of a person, their picture, exploiting that right, Nigeria does not particularly have a legal framework like other countries, right? So we do not have a specific law on image rights protection. So what you would find is people protecting their image rights by extending the provisions on privacy in the Constitution, by enforcing their rights to privacy under the data protection regulation, or even stretching it and instituting an action through person off if their goodwill has been misappropriated. So we do not specifically have a law in Nigeria on image rights protection.
You mentioned that people would normally also fall back on the Constitution and then enforce the constitutional rights, which then indirectly has an impact on the image rights. This reminds me of something that quite happens a lot in South Africa, where people will institute a privacy claim instead of an image rights or identity claim, even though the facts show that there's an overlap here for what we call image rights and what we deal with under privacy laws. So another thing that I find interesting about the similarities that I'm noticing here is that the Constitution itself has sufficient basis to protect these interests, even though there is no outright legislation or specific regulations that deal with image rights.
Yes, to an extent, right? But we also cannot deny the importance of having sort of like a specific legislation that is tailored towards that, towards protecting the image rights of people, right? So what would usually have is, with image rights, most people that are usually concerned about their image rights are, celebrities who have sort of made a name for themselves, right? Who have a reputation, who have a goodwill, and they have what we call social capital, right? And their brand image, they can convert sales for companies and, for products, right? And so they are very, very particular about their image rights. To that extent of, commercial exploitation of those sort of rights, putting it under the blanket right of privacy might be sort of a stretch. So usually what we would have is, we have celebrities who are in tune to the need to protect their intellectual property rights. They protect their rights through trademark or copyright, right? So they would. So if there is a sort of slang or a slogan that is associated with a particular celebrity, say a social media influencer or an actor or a musician, what they do is they trademark that slogan because it's sort of like a part of their image, right? It's sort of like an extension of their personality that they've built. So what they do is they take that part of their personality that they can protect under intellectual property law that exists with the trademark law in Nigeria. And so they register this trademark. If you follow the case of the comedian in Nigeria, a social media comedian, I wrote it about it on my LinkedIn. He has a particular phrase that he uses in his social media skits, right? Something huge. And so some companies used that term for a marketing campaign. And so he instituted an action. And he was able to do that because he had trademarked that term, that slogan. However, another part of the action I instituted was the fact that his image, a picture, an animation that sort of looks like him, or his usual posture, was also used in that marketing campaign. Now, because Nigeria does not have a specific law on image rights, it was particularly difficult to, from the conversations online with experts in intellectual property, it was difficult to sort of like institute a specific action because that specifically bordered on his image rights, right? So what the best sort of solution that he could use was to institute an action through passing off, right? Because that relates to protection of his goodwill. But as to the extent of protecting a specific image right, there is no legislation that centers specifically on that. And so that's sort of creates a loophole, if I may say, right? So
this case about something huge, what I'm noticing when you mention the fact that it when I listen to the facts, it's dressed up like an image rights issue, but really, the only way to get enforcement is through IP and what I would call a bit of competition if you're starting to talk about passing off. A bit of so there seems to be an intersection here between intellectual property, competition law, and it's overlapping with what is supposed to be image rights protection, but it's non-existent.
Exactly. So because of that loophole that exists in the legal framework, now we now have a situation where people now have to adapt something similar, something closely related to successfully bring an action, right? So, yeah.
But what is the? I want to build on this intersection because I'm wondering what is the burden that a plaintiff has to now carry to try and find all these different ways to get to the destination when the destination sometimes could be as easy as this is an image rights question. You've exploited my personality traits. You've exploited my image, my photographs. You've created this fictional image that looks like me. So there's definitely an exploitation of personality and likeness, which is a direct violation of image rights. What kind of burden does this bring, both financially, practically as well, for plaintiffs?
Yeah. So, because if you have to bring an action in persona for the tort of persona here, the onus falls on the plaintiff to establish certain facts. Yeah. So you have to establish that this, for instance, this slogan is closely associated with my person, with my brand. And so that for an average person, when they hear this slogan or when they see this image, they automatically link that image to my person. That's one. Now, it's also important for you to establish that there's sort of a misrepresentation going on. And so when people see this campaign, they can automatically assume that I have something to do with it, and that is sort of someone biting into the goodwill that I have built. Now, so people like to argue that if you do not have a business that is being confused with, so say someone uses your image for a particular campaign, but you do not have a similar business, how can you establish that you've suffered some loss? Now, I like to argue that the loss you suffer is not only in the fact that you do not have a business that you're exploiting. It is in the fact that you have invested to build your goodwill, and it is yours, and that you have the exclusive right to exploit your own goodwill and your own personality, right? And anyone who tries to bite off that without your due authorization is infringing on your rights. So that's basically.
I totally agree with you about the falsification issue, and I could even, as you were speaking, think about a case in South Africa that involved Basitsana Khumalo, who is a former Miss South Africa and a very prominent figure in the public domain. She was shopping in a cycling store, and a picture was taken of her and then subsequently used in an advertisement for that store without her permission.
Okay.
So she brought a claim on the basis of both privacy and identity, which is image rights in our context. And she basically successfully showed that there is falsification in the advertisement because it tells people that she's consented to this advertisement.
Exactly. Yeah.
And I think even though she is a celebrity, even ordinary people who are non-celebrities can use this argument that you're making it look like I was part and parcel of this campaign when I wasn't.
Exactly. Yeah. Yeah. That's totally correct.
Sure.
Okay, so this case that you mentioned sort of brings my mind to the intersection between, a photo, the rights in a photo, right? In a photograph. Yeah. So we know that under copyright, when a photo is taken, a picture, when someone snaps a picture, the right in the picture that is taken automatically subsist in the person who took that photograph. That person owns the copyright.
Yes.
It doesn't matter who is in the picture, right? So it is the photographer who owns the copyright. So that sort of reminds me of the Banira case in Nigeria. And So this person, a photograph was taken of her, right? And that photograph was used on billboards and for advertisements and all the rest of that. However, those who used the picture for the advertisements on billboards, they claimed that they got the rights to use the picture from the person who took the photograph. Do you understand what I'm trying to get at? So so they claim that they got it through a licensing agreement with the person who owns the copyright. Nothing about the image rights now. So, and the judge ruled in the favor of those people against the person in the photograph. And one of the things the court said was that, first of all, she should have added the people who took the photograph, who owns the copyright in the photograph, to the case.
Yeah.
So the case was struck out based on that technicality too. But that sort of like establishes something in our IP legal framework in Nigeria. So it's there's sort of like a distinction between copyright and image rights. So a person might have the image rights in a particular photograph because they are the subject matter of the picture, but that does not automatically confer on them the copyright.
True.
And so these are issues that if anyone wants to bring an action for the use of their image or for the infringement of their image rights, these are important issues that they have to consider.
And this is I would call it a clash of interest that I've always been really concerned about. And it's something that I spoke about one time when I went to the World Intellectual Property Organization for a Teachers of Intellectual Property Law colloquium. My topic was exactly about this clash, that while people, photographers and artists, my focus was on artists, that artists who draw people, out of that inspiration. You draw a prominent figure or even someone in the street. And sure, you have the copyright in the artwork itself because you stand in the position of the author, even according to copyright legislation in South Africa.
Exactly.
You are author. But what about the image rights of the person who finds this portrait of them posted, for example, on social media, and they never maybe consented to be the subject of that portrait?
Of that photo, exactly.
And it's something that I've always had this opinion that in this case where there is no permission between the subject and the author, I honestly think image rights should trump the copyright there, because what taints copyright in this instance is the fact that you didn't ask for permission. And I think that would be contrary to good morals, and thus copyright should not vest. It's an argument that I was advancing when I was presenting this topic, because I do believe that this clash, it's quite a dangerous one, which brings me to the question that I want to ask you about when artificial intelligence media comes into the picture, like deepfakes. Because with deepfakes, here you have AI developing videos, pictures, audio, but they are using people's voices and pictures and all that. And sure, there's a clear violation of image rights with the misuse of people's personality traits, but isn't there copyright then in the final product? Because it is sort of a new kind of product, to the media itself, or the post, or the picture itself, or the audio itself. So how does media like this challenge the Nigerian approach to the current protection that you have for image rights?
So with respect to AI and computer generated works, right? So like I said earlier, Nigeria does not particularly have a robust framework that covers issues like that. And so issues like that are still very much in the realm of pure academic debates and the rest of that. But in my own opinion, right, with works generated by AI and computer programs. If you look at how the structure of copyright is and how copyright is being vested, right?
Yeah.
So what would make a work eligible for copyright? The work has to be unique. It has to be in a permanent form of medium of expression, and it has to be sort of original, right? And the rights to, when the work meets all these criteria, the rights is vested in the author. Now, an artificial intelligence with AI and with a computer is not an actual person, right? So that links you back to, okay, who created the program, who wrote the software that sort of developed the algorithm or the computer software that eventually developed this copyright work, right? Now, in the case of Nigeria, Nigeria protects, computer softwares, like the code is protected under copyright. So when a person writes a code that eventually develops into a computer software, now the code itself is protected by copyright. So I would assume that when you trace this link, right, from, okay, what is the copyright work? How was it created? Oh, through an algorithm or a computer software. Oh, who created this computer software? It goes back to probably the software developer or the software programmer. I don't know if that makes any sense. So that is sort of my own opinion on how that whole situation may pan out.
It's quite interesting because I tend to worry when I look at, I know on YouTube there's a lot of educational material on deepfakes, but I tend to worry about the misuse of people's images in the space. And I keep wondering if a company wants to claim that, well, we have copyright over certain material because it was produced using our AI-powered systems.
Yeah.
Which rights should be preferred, the copyright or the image rights that are violated? And so in the South African context, because we protect image rights mainly under the right to identity, and the fact that the right to identity is part and parcel of human dignity and related to privacy, it sort of always goes back to a balancing of rights from a constitutional perspective.
Exactly.
And human dignity as a constitutional right, as well as a constitutional value, has a lot more, I would say, good standing to trump the property interests of someone who wants to claim copyright over something that violates someone's image rights in South Africa.
Yeah, and I agree with you, right? I think that, the constitution of any country is sort of like the ground norm. And like I said earlier, specifically in Section 37 of the Constitution of the Federal Republic of Nigeria, every human being has a right to their privacy. And in the context of that provision, what privacy means is their personal information, anything that has to do with their person, right? They have the right to protect that information. And this is also backed up by the data protection regulation that we currently have in Nigeria. So yes, if a person's right to privacy has been infringed upon through the creation of a copyright work, of course, that person has a right to contest the validity of that work and then to seek redress if indeed their privacy or their right to their person has been infringed upon. So there's a clear legal framework for the protection of the privacy of people under the Nigerian law. Like clearly, it's not debatable at all.
So what I also see that's interesting with the recent surge for data protection laws over the past decade is that data protection regulations are going to now potentially overshadow this image rights space, because a lot of times when I'm presenting, whether it's a seminar or something like that, I'll be asked questions like, why is your focus not on the Protection of Personal Information Act for this topic? And I always emphasize how in our country, our data protection legislation specifically looks to private and public bodies as the responsible parties for processing information. So in the one-on-one relationships, which is typically the case on social media issues, that kind of legislation cannot step in. It cannot apply. It does not fit into its scope with the one-on-one relationship because it specifically regulates public and private bodies. And so in such instances, we still need this common law right to identity, which is our image rights protection system, to be good enough to withstand the challenges that we see on social media as well as in the face of artificial intelligence developments.
And you make a very good argument, but I would assume that probably what the pushback has been is because the concept of image rights, like I said earlier, is always seen from the perspective of protecting the rights of sort of like celebrities or people who have the goodwill and they have a big brand to protect, right? Yeah. So that's sort of like the idea when anyone thinks about image rights, basically. That's what comes to mind. There are the rights to protect this person's image. Now, why would you necessarily really want to protect a person's image? It is because there's some sort of economic value that is attached to that person's image. And who are those who can say that a level of economic value can be attached to their image? It is, celebrities, influencers, and, people who have sort of built a big name for themselves. So, of course, that should not trump the need to protect the rights of, the average person. So I do agree with you.
Yeah, very true. This conversation takes me back to the first image rights case I came across in South Africa. I was still a student a couple of years ago in the undergrad. I think it was 2013. And it concerned the case of a young 12-year-old girl. She was on the beach with her family, and she was obviously wearing a bikini. And a freelance journalist took a photo of her from the back without her permission, and that picture was used in a Surface magazine, and it had very derogatory statements on the cover of that magazine. But the problem that I had with this particular thing, this particular case, despite all the other legal issues, my concern was, how can we equip people who work in these spaces, like freelance journalists, photographers? How do we equip them to understand the damning effects of an action like that? Because I think the freelance journalists did not know that what they were doing is contrary to the law. But it ended up in court, and the girl actually won the case, got damages. But I always think back to the fact that her age, number one, is a very critical issue in this case.
Yeah, it's a critical factor.
And the second part is when people around her community started seeing the picture, they started talking about it, started asking her about it, as if she had consented to appear on the cover. And even if she got reparations in the form of a damages claim, she can never take that thing back. Exactly. Yeah. Exactly. Yeah. So I think what I want to ask you at this point and in closing is to provide our listeners with points or tips that artists, photographers, influencers, upcoming celebrities should consider when they navigate their image rights, when they try to also navigate the image rights of others, navigating contracts that will potentially compromise their image rights? Can you maybe give us a few pointers here?
Yeah. So from the case that you described, I would assume that ultimately it was the people in charge of the magazine that eventually put that picture out.
Yes.
Not the freelancer. And the point I'm trying to make is that with big corporations, right, that have access to the best legal advice they can get, there's really no excuse for them not to do their due diligence when putting out material, whether a marketing campaign, whether a picture, to make sure that no rights have been violated. I mean, it doesn't particularly take too much to do your due diligence before putting out something that would eventually blow back on your brand and on the goodwill of your company. So that's like the first point that I'd like to make, that, companies and businesses should, do due diligence and make sure that they're not infringing on the copyrights or the image rights of people before putting out any material at all. And also, specifically with relation to the intersection between copyright and image rights, right? So because this sort of relationship is usually a person-to-person relationship, and it would usually, to a very large extent, be guided by the law of contract. Now, like we said, based on principles in copyright, whoever takes a picture owns the copyright automatically. That's how copyright works. Now, except the right is now transferred or assigned to another person. And so it is important that, as a person, when you hire a photographer or you hire a person to take your picture, do something with your picture, you sort of make it clear. Is it a work for hire? Are they contracted? Do they own the copyrights in the image? And these sort of things are what can be incorporated in contractual agreements and, provisions in the contract. And so I believe that, so basically, companies doing due diligence and, persons paying more attention to the sort of contracts that they sign. And also, I think, like you said, we have most of these issues because there's very little awareness on what intellectual property rights are. And so as a society, we need to do more to sort of increase awareness and let people know what their rights are and why we need to protect these rights and how they can go about protecting the rights. Yeah.
That's true. One of the main concerns in my doctoral thesis has been a unique group. I say that it's a unique group because I think they're on the rise, and these are social media influencers. Yeah. My biggest concern here is that, as you mentioned earlier, image rights are normally associated with celebrities, people who are famous, and not really with the non-famous person. So my concern is influencers are usually in a space where they're moving on this continuum from non-celebrity towards celebrity. And every time I hear the argument that these rights are more suitable or more meaningful to protect celebrities, I always ask myself that this influencer phenomenon creates this group of people who are not catered for then in this argument, because we're looking at it as it's either you are a celebrity or not, and yet this group is really moving on a continuum. It's quite an interesting thing that I've been grappling with, which is why I'm always interested I'm always wondering, how do they negotiate their image rights in these contracts? I'm very interested in that.
Okay, so yes, in the case of Nigeria, to my knowledge, most of these social media influencers, right? It has sort of become how do I put it? An actual career, right? They are content creators, right? And so they actually work with professionals. They have their own managers. They have lawyers that work with them. So as I believe that, for anyone who is a social media influencer, it is their responsibility to actually take care of their own brand, work with the right people that know how to protect their interests. Now, for instance, there's something huge we're talking about. Now, whether it's going to succeed with his case is another issue entirely. But it takes real ingenuity for him to have actually gone ahead to register that trademark. It shows some level of intentionality with the fact that he knows that he needs to protect his rights, right? And so I feel like that's sort of the actions that we need social media influencers to take for themselves, because honestly, you cannot depend or rely on the government and wait for them to come up with the legislation. So for the time being, you have to make do with the avenues that you have. And of course, there are those avenues with intellectual property protection, with protecting your rights generally, the right to your privacy and all the rest of that. And so I believe that, social media influencers should take the available avenues that we have, really, to, sort of protect these rights. And to also, be careful of this sort of agreements that they enter into with, with big brands and big corporations and all the rest of that. Yeah.
So what I got from you as one of the nuggets that I could pick out here towards this idea of influences is that it is wise to corporatize your influencership.
Yes.
Yeah, and really systematize the whole thing, have even if it's a self-regulating policy in place.
Yes.
Enlist lawyers, people who work on image brand development, enlist people like that who are going to change your affairs. Yeah.
Because I mean, in the end, they do actually make a lot of money from this thing that they do. So it's only wise to protect at least your economic interests, right? And put your house in order. Yeah.
Yeah, because it will go a long way to serve as evidence.
It will go a very long way, definitely.
Yeah. All right. Oh, I enjoyed this conversation.
I really did.
So, in closing, for our audience, especially people who want to get in touch with you on your work and all of that, could you maybe share how could we contact you either on LinkedIn, Twitter, other social media platforms? Tell us how we can find you.
So on LinkedIn, Awoyemi Ayomide. On Twitter and Instagram, at Mide Awoyemi, MIDE Yeah.
Awesome. Thank you so much for joining us. It was a pleasure speaking.
Thank you very much for having me. I'm so grateful.
Remember to control your image rights. This podcast is based on research supported by the National Research Foundation of South Africa, grant number 121887. But the views and opinions expressed in this podcast do not represent the National Research Foundation, its management and governmental structures.